Good morning, Dali.
Morning, Teresa. Hello?
Can you hear me? Hello.
Yes.
Hope you're hearing me well.
Yeah, I'm hearing you.
Can you mute your mic?
From
Yeah?
Hello?
I'm saying you're supposed to mute your whatever. Your
Okay.
background is having noises. Let's wait for other students to join. Yeah? Good morning, Munira.
Good morning, teacher.
Good morning, Brian.
Good morning, Malim.
I think we can continue. Eh? Let the rest join
Yes.
us along.
It's okay.
So let me share what you're going to discuss.
Okay.
So we are going to discuss about types of employment contracts. This because I had already shared a video that was explaining about the employment contract. And in brief, I could say that employment contract is always a binding agreement between the two parties, that is the individual employee and the employer. So having understood that employment contract is an agreement between two parties, then we also need to understand about the types of employment contracts and what we can still get in these employment contracts. Like that when you are employed, you are aware or you know about your rights, duties, and responsibilities as an employee. So we're going to briefly see four types of employment contracts. And the first one is a contract of unspecified period of time, meaning this kind of a contract is there for a fixed period of time, whereby it can come to an end by a notice or by resignation, by death, or by any other way in which an employee can be separated in an organization. The next one is the contract for specified period of time. And this in most cases, it is for the contractual basis or on contractual basis. Maybe you are signing an agreement for 2 years or for 5 years or any other duration. Upon expiry of this kind of duration, then that kind of a contract can automatically come to an end. I believe that some of us knows about the law of contract, and the law of contract always has for different elements. For example, you can have of an acceptance, meaning if there is an offer, then it is the employer. Acceptance is the person accepting it. So you're going to accept the contract based on exactly what you see it is best for you. The other thing is a contract for a specified task. For example, maybe you've been contracted maybe to do a building of a house. When the building of that house is complete, then that kind of a contract comes to an end automatically. The other thing is a contract for casual employment. And maybe an employment contract. Understand that saying all running what is contained section 10 section 10 of, and there are very many maybe employment which may be employment, like in most cases, immediately after 2 months, and industrial court description of the employer understand, and we always say that job description contains the duties and responsibilities of the employee. Another thing is the date of commencement of the employment. Let's say you sign a contract today. Today is 22nd, and you're supposed to get this kind of a contract after 2 months. Then month of June, at 22nd there, you're supposed to be given this kind of a contract. Meaning, in this case, your contract commenced on 22nd of April 2021, and that should always be captured in your contract. The other thing is the form and duration of the contract. Is it permanent? Is it on a casual basis? Or is it which type of a contract? The other thing is the place of work. In this case, the contract must have to mention exactly where you're supposed to be performing your duties. Let's say your organization is having branches. If it is having a branches, then you should not be, the contract should not be talking about the main branch, but should be talking the branch that you always report. Then the hours of work, if it is 8 hours, if it's 12 hours, if it is 16 hours, if it is 24 hours, or whichever time. But remember, in Kenya, the standard working hours is always 8. Above that 8 hours, maybe it is going to be subjected to maybe a commission pay based on exactly what you're going to perform. But that thing must have to be agreed on a mutual basis, not a situation whereby one person is making a decision on your behalf. The other thing is remuneration, scale or rate of remuneration, the method of calculating that remuneration, and details of any other benefits. Like in this case, when you are processing the payroll, what are you supposed to do with this payroll? The contract must have to state clearly on how an employee can access his or her own payroll, how to make a complaint if that payroll is not the desired one. Then the other thing is any other prescribed matter that can still be in line with your work as an employee in an organization. So from the notes I gave, you find that there are this kind of a repetition of what is exactly contained in the act itself. So these are some of the notes I had made some kind of a summary, but this is exactly what is contained in the act. So if you see this one, you can still find that they're the same as what is there. Then we also have the content of employment act. And in this case, from the notes I shared to you, you'll find that this Employment Act is divided into 6 sections or parts. That is, we have preliminary, we have conditions of employment, we have foreign contracts of services, we have employment of women and juveniles, we have general, and we also have supplementary. What is always contained in the first part, that is preliminary, you find that there are different provisions of the Employment Act. Like we have the Armed Forces or the reserve as respectively defined in the Armed Forces Act, the Kenya Police, the Kenya Prison Service or the Administration Police, and also the National Youth Service. So you find that maybe some of the other civil servants have not been mentioned here, but in this case, how these people are employed are based on their own employment acts. Like we need to have the act of the armed forces, the Kenya Police, the National Youth. So that is things that we ought to understand. So that whenever you are getting an employment, then you know exactly where you're supposed to have your own issues. Take an example that maybe someone from armed forces has done a mistake. Can you take this person to industrial court? Can you take this person to the ordinary court? Or where are we supposed to take this person? We are supposed to understand that the armed forces have their own special court called court martial. So whenever they do anything that is going to breach the terms of the contract, then that is where you can get the remedy to these people. We also have something called Labor Advisory Board, and you can see exactly in this kind of Labor Advisory Board. So this should always be having the members appointed by the minister, always during the labor advisory board. And in this case, it contains the following provisions. That is, the minister at any time can set appointment of a member of the board unless his appointment is so cancelled. Each member of the board shall hold office for 3 years. That is upon the expiry of these 3 years after the appointment, then the minister in charge of the Labor Advisory Board should do another appointment. If the chairman of the board ceases to be the member of the board, he shall also cease to be the chairman of the board, and immediately another person should be appointed now to chair the board. And number 3, there shall be paid out of money provided by the parliament the members of the board, including the chairman, in respect of their office as such, and other reasonable allowances in respect of expenses properly incurred in the performance of their duties, as may be determined by the minister with the consent of minister for the time being responsible for finance. So it is all about in agreement on exactly what should be done, because you cannot be aiding a board and probably maybe you are not going to get any kind of remuneration. Like what I could say is that what motivates an employee is always the payment this person is getting. That is what is contained in part 1. And I would recommend that each one of us to download an employment act. So you download for your own, and the one I prefer is the Employment Act for the year 2007, and the other one for 2010. We also have the conditions of employment. A good example is whenever you are an employee, you're supposed to be paid. And in this case, how does this employment give us a protection or security as far as the employee and the employer is concerned? So subject to this act, the entire amount of the wages earned by or payable to an employee in respect of work done by him in persons of a contract of service shall be paid to him directly in the currency of Kenya. Even if you are a foreign employee working in our country, like we have the Cuban doctors. In this case, they entered our contract, and for them, they should be paid in our own currency and directly to their account. Unless if for this case, you are performing an activity on a contractual or a casual labor, whereby now the employer is supposed to give you the money direct. And in this case, if an employee requests in writing in case of an agreement between a trade union and an employer, payment may be made in form of the following: into an account at the bank, by a check, postal order, or money order. Number 3, in absence of an employee, the person other than the employee, if the person is duly authorized by in writing, by him writing to receive the wages on his behalf. So what I'm saying is that it is always very important that whenever you are entering into a contract, which type of contract are you entering, and what kind of a benefit are you going to get from this contract. The other thing is payment of wages shall be made on a working day and during working hours, or at the near place of employment. So the payment should always be made in such a way that you're going to access it during the week and not during the weekend. So in most cases, if it is on a Monday, then if it is on a weekday, maybe it should be between Monday and Friday, and not during the weekend. So meaning, if you are supposed to receive your salary or your wage okay, I'm seeing some kind of a concern. Daddy, what is the problem?
Sorry, it is just an error.
Okay, fine.
Okay.
So I was saying about payment being made on a working day. So what I'm saying is that as an employer, you're supposed to pay this person exactly between Monday and Friday, or just during the working days recognized by the employment Act. The other thing is payment of wages shall not be made in any place wherein intoxicating liquor is so or readily available for supply. Like where you're supposed to be making some payments for the employees, then it should not be a place near to uh, maybe a place I can buy or you can buy drugs, for example, alcohol. That should not be agreed because you might be tempting the other person maybe to buy uh, maybe the liquor or the alcohol using the money, and probably maybe the business also is yours. That should always not be acceptable. And always when the wages are due, then the employee should be entitled to. After working, is supposed to be paid, and no extra should be done. And if it should be done, it should be done in a reasonable way and in a sufficient way. So in this case, when that thing or when the wages are due, these are some of the things that each and every employee should be entitled. That is, when a task has not been completed, then you don't expect to be paid unless you had agreed that even if the task is not completed, you're supposed to be paid. At the option of his employer to be paid by his employer at the end of the day is proportional to the amount of the task which has been performed or to complete the task on the following day. So it depends on how you have agreed because maybe you've done a work that maybe it is 3/4 to its completion. Then you can agree that you be paid part of that job. So that when you come to finish, then the remaining amount shall be given to you. In the case of casual employee, at the end of the day or just at the end of performing that activity, because casual laborers can perform an activity maybe for activity supposed to run for the whole day. Then when that time elapses, you pay this the amount. Number three, in case of an employee employed for a period 1 month at the end of each month. So this is what we normally refer to as being given the salary. But remember, salary can only commence immediately after the 14th day of the work. The next thing is in the case of an employee employed for not that one, but where an employee summary dismissed for a lawful cause, he shall be paid on dismissal all monies, allowances, and benefits to him up to the date of his dismissal. But at times, there are those things that maybe can warrant someone being summarily dismissed. If it is maybe due to cross misconduct, maybe you are drunk, you are stealing, or you are fighting at the workplace, then at some point you cannot even be paid the amount. But concerning this point I'm just explaining here is that you're supposed to be paid your dues when a summary dismissal is done. We also need to understand about deductions from the wages. At the time of processing the payroll of an employee, they are what we refer to as compulsory deductions to be made from the employee. And in this case, there are the obvious that we know. For example, pay as you earn, the NHIF, the NSSF, and maybe any other compulsory deduction that is allowable by the contract and subjected to your payroll. So an employee may deduct from the wages of his employee the following: one, any amount due from the employee as a contribution to any provident or a scheme or any other scheme approved by the Labor Commission to which an employee has agreed to contribute. And I've already given the examples of those ones. Pay as to earn, maybe save as to earn. I still talk about the NHIF and NSSF. But remember, many people don't even maybe subject the employers something called a SIA, that is save as you earn. They only subject the employer to deduct the compulsory deduction. total amount for any damage done to or loss of or any property lawfully in the possession or custody of the employer occasioned by the willful default of the employee. So probably you've been given a property to use, then unfortunately maybe it has been damaged. So in this case, you're supposed also to agree with the employer on how this kind of a deduction should be done, but not just deducting maybe from your salary and probably getting a zero salary. No, that should not be the best way to perform such kind of a deduction. The other thing is any amount paid to employee in error as wages in excess amount of wages due to him. Maybe you are supposed to be given, let's say, 100,000, and someone has given you 200,000. You see, you have an excess of 100,000. So in this case, the employer will be now compelled to be deducting part of this amount, but not now to refund the amount from your account. It was not your fault, and therefore it will be now the duty of the employer, together with the employee, to agree on how that amount will be deducted until when it is zero. We also have any amount which is authorized by any written law for the time being force. Take an example, maybe you're having an upkeep with someone in a different place, and it has been arrived at by the court of law. So in this case, it also be there in a lawful way, not by a forced way. And the last one is any amount in which the employer has no beneficial interest, whether direct or indirect. We also need to understand that in the employment contract, we need to have some other benefits like leave, housing, health, and welfare. In that, every employee shall be entitled. For example, if it is leave, then you're supposed to be entitled to 21 working days, or just at 31 days. In some instances, you can get someone being given for 2 days to go on or to proceed on leave. Now, the things that we also need to understand, for instance, uh, after every 12 consecutive months of service, with this employer to not less than 21 working days of leave with full pay. So, not necessarily that when you go to leave on leave, when you proceed on leave, the employer should not pay you. No, it's supposed to be paid this kind of an amount. And there's some of the things that can make you to be outside the working place, but still the employer is going to be compelled to make such kind of payments. So in this case, there are things that you can still mention there. For example, a woman employee shall be entitled to 2 months maternity leave with full pay. In most cases, we normally know it's three, but you can now see contract or employment act. They're supposed to be two two the leave referred to in subsection 1 shall be additional to all public holidays, weekly rest days, and any sick leave, whether fixed by law or agreement, in respect of which as employee is not required to work. The other thing is every employee shall be entitled to at least one rest day in every period of 7 days. So we all know that a week has got 7 days. So with these 7 days, you're supposed to be given one day to rest. The thing is, every employer shall at all times, at his own expense, provide reasonable housing accommodation for each of his employees, either at or near the place of employment, or shall pay to the employees such sufficient sum as rent, in addition to his wages or salary, or a reasonable accommodation. So in this case, if you cannot provide the house, maybe within the premises of the organization, then you can still give these people a house within that vicinity. And if that is not the case, then you're supposed to give this person sum of money to go and do a rental on his or a comfort zone. The other thing is every employer shall provide a sufficient supply of wholesome water for the use of his employees at the place of employment. So it is something that is very important that the employer shall have to provide clean water at the workplace for people to use. And probably our time is somehow running, but I think we've been given an additional 9 minutes. Let me hope we are going to finish what we are doing. So one thing that there is need to have sufficient water for each and every person at the workplace. The last thing there is every employer shall, where provision of food has been expressly agreed to in or at the time of entering into a contract of service, ensure that every employee is properly fed and supplied with sufficient proper cooking food, the utensils, and at the employer. Then it should be done. We need to understand about summary dismissal. When you are carrying out summary dismissal, it should what we call gross misconduct of the employee at the workplace. So what I could advise is that whenever someone does something that is going to breach the agreement or the terms of the service or the employment of that person, then this person should be given what we call a summary dismissal. But still, you must have to carry activity be a claim dismissal, then can be proved, then person. So there is a video I'm going to share as soon as possible about contact that is also attached with summary. Wish to some we start from who? Trial. Trial, say something. Okay.
Yes.
Yes, Trial. Brian. Brian,
Malu?
is there any challenge?
No, currently
Yes?
I don't have.
You okay?
I am okay.
Angela?
I'm okay.